Moot Court Board, and Jade Topman is the other co-chair. And along with Jade, I would like to thank all of the competitors who participated in this year's Hardt Cup. Would the new members of the Moot Court Board please stand up? If everyone could please give them a round of applause. The Moot Court Board would like to thank all of the faculty, Duke Law administration, and Duke Law alumni who helped make this competition such a success. In particular, we would like to thank Dean Levy and Dean Miller, Professor Lewis, Professor Young, Professor Morris, Dennis Duffy, Dean Sherman, Dean Gustafson, Dean Newman, and Jim Maxwell. We would also like to thank Thompson and Knight for their support. Jade Topman will now say a few words.
Thank you again for coming. I would like to thank the board members in particular for the amount of time and effort that they dedicated to judging and assisting our Hardt Cup coordinators with coming up with such a fantastic event. And especially I'd like to thank Tim, Jim, and John. For those that don't know, the Hardt Cup planning and running process is a labor of love that I think only other Hardt Cup coordinators know. So they have dedicated the past month of their life relatively around the clock to making sure that this was a successful event. So as you hear these competitors judge, or these competitors compete, please give them the respect they deserve, but also keep in mind that in the background were these three gentlemen that were making everything run smoothly. So thank you for your presence. Thank you to the three of you, and I'll turn things over to them so they can introduce this competition and our great competitors. Thank you.
Good afternoon. My name is Jonathan Williams. I'm one of the Hardt Cup coordinators. I'm just going to give a few words about the history and purpose of the Hardt Cup. In the fall of 1962, the law school community was shocked and saddened by the death of A. Lee Hardt, who had just finished his first year of law school here. The class of 1964 chose upon graduation to dedicate this cup to his memory. And since then, the Moot Court Board has run an annual tournament for first-year oral advocacy that continues to this day. Competition features 3 rounds, first of which, as many of you know, is the output of the legal analysis, research, and writing problem. Subsequent rounds feature new problems written by us, so any complaints go to us. And then after that, the top 20 students are chosen for the Moot Court Board, and the top 8 go on to argue in the subsequent rounds. At that time, the round's time increases to 15 minutes. Everybody's still arguing on and off brief until it's narrowed to the field of 2, which brings us to today.
I'm Tim McGinn. I'm just going to introduce our competitors for today and our judging panel. Start with Brendan Groves, who will be representing the petitioner, Patrick Ninian. Brendan graduated from Pepperdine University with a degree in political science in 2007. While he was enrolled at Pepperdine, he worked for Ken Starr, who was at that time dean of the Pepperdine University School of Law. He's twice worked for the U.S. Department of Justice in Washington, D.C., most recently as a legal intern for the Deputy Attorney General. And when he graduates, he'll be serving as a JAG officer in the United States Air Force, for which he's already commissioned as a second lieutenant. Representing the respondent, Attorney General Mukasey, we have Tim Grinsell, who graduated from Dartmouth College in 2005. There he majored in Russian and in cognitive science. Following that, he spent 2 years at Carnegie Mellon, getting his master's in logic and computation. He's from California originally, and he is interested in legal theory and the history of American legal thought. Got everything? Good. All right, I'll introduce the guest judges now. Our Chief Justice for today will be Chief Judge Robert L. Hinkle, who is from the United States District Court for the Northern District of Florida. Mr. Hinkle, or I should say today, Chief Justice Hinkle, graduated magna cum laude from Florida State in 1972 and received his JD magna cum laude from Harvard School of Law in 1976. Prior to his appointment to the District Court for the Northern District of Florida in 1996, he clerked for Judge Irving L. Goldberg of the Fifth Circuit and then entered private practice. Then we have Chief Judge Louise W. Flanagan from the United States District Court for the Eastern District of North Carolina. She'll be Justice Flanagan today. She graduated magna cum laude from Wake Forest in 1984 and received her JD from UVA in 1988. Before her appointment to the district court, she worked in private practice and as a part-time magistrate judge. And on a personal note, prosecutorial ethics professor Dennis Duffy says she's both tough and fair. Our final justice today will be Judge Morrison C. England, United States District Court for the Eastern District of California. Judge England received his BA from the University of the Pacific in 1977 and his JD from the University of Pacific McGeorge School of Law in 1983. Prior to his nomination to the District Court for the Eastern District of California, he worked in private practice and served in the U.S. Army Reserve JAG Corps. I'm going to turn it over to Jim McDonald now to explain today's problem.
As Tim mentioned, what you're witnessing today is an argument before the United States Supreme Court. It comes to the court on a petition for certiorari from the United States Court of Appeals for the Fifth Circuit. It's an actual case that'll be heard by the court in the the fall 2008 term, and it's been retitled here as Ninian versus Mukasey. The actual case, if you're actually interested, is Mukasey versus Mukasey, but we wanted to make the names a little easier to pronounce. Good job. The question concerns the persecutor exception to the asylum laws of the United States. A person who has assisted, participated, and the competitors will get into the rest of the language, in the persecution of another on account of their religion or other affiliation is barred from receiving asylum or withholding of removal in the United States. And the question before the court is, does that exception apply to someone who was involuntarily coerced or was coerced into involuntarily participating in those acts? And it should be briefed well on both sides. The competitors you're seeing today have argued it excellently, and we hope you enjoy. Thank you.
All rise. The Supreme Court of the United States is now in session to hear the case of Ninian v. Mukasey. Chief Justice Hinkle presiding, accompanied by Justice England and Justice Flanagan. Oral arguments will last 20 minutes. Petitioner has reserved 2 minutes for rebuttal.
Please be seated. The case is Ninian versus Mukasey. We'll hear from the petitioner first.
Mr. Chief Justice, and may it please the court, Patrick Jeremiah Ninian, a man persecuted by his own Eritrean government and even forced to guard his own place of imprisonment, should never be confused with his persecutors. The Immigration and Nationality Act of 1952 justly affords relief to those who, like Mr. Ninian, are persecuted, while rightly barring relief to those culpable of persecution. 2 reasons strongly suggest that Mr. Ninian cannot be held culpable for any act of persecution. First, analyzing Mr. Ninian's conduct in light of the equities and the coercion under which he acted confirms his lack of culpability. Second, Mr. Ninian should be allowed the defense of duress. This defense comports with the statute's text, its purpose.
How does that fit with the United States Supreme Court's previous decision, Federico?
Your Honor, in Federico, what was at issue was the voluntariness provision and whether that should be allowed into Section 2 of the Displaced Persons Act. That court held that instead of explicitly allowing a voluntariness exception, what one does instead is engage, and this is in footnote 34, in an individualized analysis of culpability. And their courts have taken that to reflect a continuum of conduct. On one end, you have the coerced. In footnote 33 of Federico, this court said the coerced looked like a working prisoner, someone forced to assist in camp operations. On the other end of the coerced, you have the culpable, someone who is voluntarily there and voluntarily...
But shouldn't we change, though, because this was a 1981 case that was dealing with a statute that was enacted in 1948 or thereabouts with a different situation entirely. At that time, you had a world war that had raged. You had countries and combatants who wore uniforms with distinctive insignia on them. That's not the way it is currently. We don't necessarily have wars against countries. As a result of that, shouldn't we as the Supreme Court start to evolve as well and look maybe beyond the 1981 case and the 1948 statute?
Your Honor, I think that's incredibly wise, especially given the circumstance that you point out. In other words, what this court I fear what would happen if Mr. Mukasey's very hard-nosed interpretation is allowed to prevail is that this court would, in effect, by de facto, really legitimize illegitimate actions. In other words, succumb to the prerogatives, you might say, of the persecutors. And by this I mean consider the case of child soldiers. And this is really under Mr. Ninian's second contention, which goes to the existence of the duress defense and the absurd results that could follow if this court refuses that defense.
But before you get to the duress defense, let me ask you this. But for any duress, do you agree that what Mr. Ninian did would constitute assisting in persecution and therefore disqualify him?
Your Honor, it may, although the immigration judge below found three things. The first is that Mr. Ninian, there was no evidence of either that he was a malicious person, there was no evidence that he was an aggressive person, and the third, no evidence that he mistreated the prisoners.
But he carried a gun and guarded prisoners. He caught them trying to escape and stood guard while they were kept in the sun as a form of punishment or execution, knowing that could lead to death. He kept prisoners from taking showers, and he would perform maintenance offenses at prisons. If he did that not under duress, he did it because he was paid, then he would be disqualified, yes?
Yes, Your Honor, if in fact, as you say, as you assert, that if that was not under color of duress, but that also totally hinges on this court's interpretation of the provision at issue in the Immigration Act, and that is the persecutor exception, which one who orders, incites, assists, or otherwise participates in acts of persecution on account of several prohibited factors, and that's race, political beliefs, etc. If on account of is taken to modify persecution, which is the normal reading that one would give to those words.
Isn't assist a very broad term? If you assist at any point, doesn't that pretty much catch everyone, just like Mr. Ninian at this point in time?
Your Honor, but persecution is different than that, because say an Eritrean kills or wounds an Ethiopian, you can't say that that was persecution per se. There has to be a persecutory motive. That's what separates persecution from other acts. In other words, like Black's Law Dictionary, the 8th edition.
But the motive doesn't have to be on the part of the person we're dealing with. You can be hired and your motive can be financial, but if for a financial reason you are helping someone else who is persecuting on account of political opinion or race or whatever, then you are assisting in persecution, right?
Your Honor, yes.
It goes back to your point about what you're modifying. On account of race or political opinion modifies persecution.
Yes, Your Honor. Again, that scenario you posed was without or in the absence of any evidence, I assume, of coercion, and therefore then I would agree with you. But however, here there's substantial evidence to indicate that Mr. Ninian was at all times coerced. In fact, when he was a guard of his own place of imprisonment, he was, of course, had been a prisoner there and was really a prisoner for the entire period during which he guarded the encampment.
Is there anywhere in the language that you would find the coercion or duress defense that you say exists? Or is that just common law or judicial gloss?
Your Honor, that's exactly onto it. In fact, of course, if duress had to be statutorily enumerated, it could really never be offered because it's never listed, or very rarely so listed, in a statute, especially by Congress. And what this court did in the Dixon case in 2007 in footnote 6 said that the defense of duress is so strongly rooted in history, to quote from Justice Stevens' majority opinion. And in footnote 7, he complimented by that by saying that when implying that the duress of defense, inasmuch as it flows, as you say, from common law, is in fact presumptively available. And therefore, Congress is presumed to know of existence, and if they wish to exclude its operation, they may, but they must be charged to do so in visible and apparent language, which they've obviously not done here. And therefore, even like the Safe Streets Act of 1968, which was at issue in this court's 2006 Dixon opinion, it said nothing, absolutely facially silent, as to the existence of any defense of duress. However, the court still allowed it because even though Congress in footnote 6 articulated a very strong fear of, this is about dangerous persons acquiring firearms, they had a very strong fear about that, and so they criminalized it. But Justice Stevens and the majority held that that was not in and of itself enough to undo a defense is strongly rooted in history as the defense of duress. In other words, there's little reason why it wouldn't apply, inasmuch as we're seeking whether or not these people are culpable of acts of persecution. It seems that this was not the case here, and it certainly will not be the case where others, such as child soldiers, have been forced to participate in acts of violence.
It's a little bit different, though, too, than the amount of time that he spent doing these activities. He was there for 4 years. Isn't that quite a long period of time to be engaged in this type of conduct when, if you compare the previous case that this court's ruled upon in Federico, it was 2 years, and that was enough to force him out of the country. And here he waits 4 years before he decides to take some type of steps to remove himself from the situation. Why? Why did it take so long?
Your Honor, the key
And shouldn't we
difference-
look at that as being one of the factors to decide this?
Absolutely. I would assert that that should be a factor of analysis. However, the key difference is this that separates Mr. Ninian's 4 years from the 2 years in Federico, and that is that Mr. Federico was allowed to leave the camp apparently at will and go into nearby villages, and even then never tried to escape, not once. Mr. Ninian's story is, of course, a different story. And first of all, there are no facts before the court today that would assert in any way that Mr. Ninian was ever allowed to leave the base. As I said, though it looked as though he was a guard, he was in fact a working prisoner during the 4 years of his duration there. The first opportunity he took to escape was apparently the one to crawl aboard the cargo container that brought him to our very shores. And I think for that reason, we should look not only to the defense of arrest, but this court has essentially two avenues. And the first is if you don't wish to allow explicitly a defense of duress by itself, you can instead dictate as a matter of law that duress or coercion is to be looked into in the individualized analysis that follows or flows from footnote 34 of Federico. And that has been done in the Eighth Circuit, for instance, in the Hernandez decision. There was a Guatemalan who was conscripted against his will.
Well, let me ask you, put your Congress hat on for a moment. Could a member of Congress reasonably decide, look, when this kind of case comes up, all we're going to have for the facts, basically, is the word of the person. It's going to be very hard to tell what the real facts are. We can tell whether persecution was going on in that part of the world because we get reports. But whether the person did it voluntarily or under duress, we're never going to have much information about that. And so maybe what we should do to make sure that we don't get persecutors into the country is just say, if you participated in the persecution, you're out. A few people who participated under duress will be excluded. Better that than to admit people who participated voluntarily. Couldn't Congress decide we're not going to try this issue, we're just going to keep them all out?
Your Honor, they certainly could, but again, there's an issue in Dixon that this court raised that completely abrogates that concern, and that is it.
But Dixon's a criminal case where
Yes, Your Honor.
we don't want to put a guilty person in jail, better to let an innocent person go free. Couldn't Congress say that's not what operates with immigration? Better to keep a persecutor out than to, better to keep one who participated under duress out than to let one who participated voluntarily in. The presumption runs the opposite direction.
Well, that would be a concern if, in fact, the alien did not have to prove by preponderance of the evidence the existence of duress. In other words, this really discounts the idea that folks will be claiming duress when, in fact, that wasn't the case, because if they claim that, they're going to have to prove it. Now, Mr. Ninian does not at all...
But then we have to rely on trial judges. I mean, we all know they're not very reliable.
No comment there, Your Honor. I respect him a great deal. But I would say, though, that, again, I think the existence and the placement of the burden on the alien, and of course, it's not as though that we're dealing with aliens who lack rights of due process. Indeed, my client has rights of due process, as does any person, though he is but an alien. And again, I think that the fact is they bear, in fact, two burdens. The first is they bear the burden through 8 CFR 208-16 to disprove persecution. And the second one is, as you say, if this court allows explicitly the defense of duress or reads it into an individualized analysis, they have to prove duress beyond a preponderance of the evidence.
So your test would be duress straight out of the criminal law. That's the test.
Your Honor, that could be a test, and in fact, following Dixon and other courts, and of course, duress is available in the civil law. Of course, it can make void or voidable at least a contract. But again, this court doesn't have to do that if it wishes, inasmuch as this is not per se a criminal case, though the punishment extracted is quite severe, being thrown abroad and denied asylum, etc. But again, you could read duress into the individualized analysis a la the Eighth Circuit has done in the Hernandez case. And
But if I read it into, as you suggest, rooted in footnote 34, into the circumstances the court can consider, doesn't your client lose? Because isn't the focus on the acts that were undertaken? Isn't that what that footnote reiterates in the case law? You've cited the Hernandez case. It's the acts, the conduct that can be considered assisting, how much the individual does, or to what degree? And didn't your client watch at least one prisoner meet his death through heat exhaustion?
Justice Flanagan, the answer is yes and yes with this addition.
Well, isn't that very different from the concerns that were expressed in the preceding footnote 33, born of musicians waiting the train to soothe persons coming to meet their death, haircuts? I mean, those were the acts. That was the conduct that the court was saying shouldn't be considered assisting. But your client's conduct is so very, very different. I feel if duress were read into that it would be very hard for that to rise up to meet and outweigh that conduct of watching someone meet their death in the heat.
Well, Justice Flanagan, your concern is a good one, and of course we empathize with that by the fact, again, saying that if the burden is placed on the alien, as it is now and as it hopefully will be after this court's holding, that mitigates to some extent, to a very large extent, any dangers of that. Also, with response to what Justice England was saying earlier about the changing tides of international violence, and that we can't allow the prerogatives of the persecutors to hold sway inasmuch as it's not just the conduct, Your Honor, it's actually the conduct coupled with the circumstances. And it's the circumstances here, just like in any other offense where you have elements of prohibited conduct. Just because someone robbed a bank does not necessarily mean that they are guilty as a matter of fact. You have to also look to excuses or justifications. Here, of course, excuse, as this court said in Dixon on page 2441, it transcends the elements of the prohibited conduct or the offense. And therefore, and this is complemented in footnote 5 of Dixon, that it doesn't have to be enumerated. In fact, it goes above and beyond that, just like it should here in regards to the persecutor exception.
Well, but what was the conduct that was excused in Dixon? It was buying the weapons, correct?
That's correct, Your Honor.
Over a limited period of time, and we have these 4 years of activity to consider.
That's correct. But again, duress, as this court said in Bailey, this is a 1980 case where this court articulated what might be the elements of duress. You look to whether there was a reasonable opportunity to do otherwise, or the Model Penal Code in Section 209 would have you examine whether a person of a reasonably firm person would have done the same. Again, if you do that, it seems fairly clear, inasmuch as petitioner was a prisoner in a military uniform, never allowed, so far as we know, to leave the base at all, that he had no reasonable opportunity to do otherwise. And again, I think that's exactly what we're asking, is that even though he may have participated in these acts, which may well amount to persecution, that his conduct may not be found to amount to persecution inasmuch as he cannot be held personally or morally culpable for these acts. And I also want to emphasize the fact that
I take it you would say, though, no matter how bad what he did, you would even take one of the circuit cases, I guess the Ba case out of the Fifth is one where they killed civilians, chopped off arms, legs, decapitated folks. I take it if you would say if he did it under duress, he can still be admitted, even having participated in those kinds of atrocities.
Your Honor, so long as he proves, again, by a preponderance of the evidence, that was born of duress. But again, in cases like that, what I would submit is relevant to the court is to see whether an individual has risen in the ranks of in the milieu of some organization, be it a rogue or a military organization. If they've done that, that may discount any possibility of duress. Also, the duration. Did they have a reasonable opportunity to escape? Things like this mitigate the fear that will allow people like that.
So you're saying mayhem and all of the things that my colleague just mentioned to you can be completely justified because you say and use the term duress?
Well, not just say
Isn't there have to be some point, a cutoff, that people can't just do anything that they wish to another human being and say, well, I was forced to do it, there's nothing else I could do? Where does it stop?
Well, Your Honor, the Ba case is actually a great example. There, Mr. Ba argued that he didn't have the intent necessary, in other words, subjective intent, but however, he did admit to being an active member, and it appears from the facts that he didn't have to engage in that of outrageous conduct in order.
His father was killed, and his sister was raped and killed. He pretty well knew that if he didn't do what his captors wanted, what was going to happen to him. So, I mean, that seems to be a pretty strong duress case.
Your Honor, I think, again, so long as Mr. Ba could prove it to the satisfaction of the immigration judge, which I assert in conduct like that might be a very difficult thing to do. The difference between lopping off heads and Mr. Ninian's is
Goes back to
quite-
my question about, couldn't Congress decide just to make a blanket rule? I mean, the truth is, in all of these cases, there's going to be lousy evidence. You're going to have the testimony of the alien who wants asylum and not much else, right?
In some cases, that might well be true, Your Honor, but again, it doesn't appear that Congress has explicitly outlawed this here. Had they, that would be a different matter, and Mr. Ninian would be certainly presenting a different course of argument before the court. But inasmuch as the Safe Streets Act presented the exact same dilemma, it says nothing facially as to the existence of the duress defense. Also, the Ninth Circuit in the Vukmirovic, and forgive my pronunciation, allowed the defense of self-defense to this very same statute because they risked it would offend the text, the on account of language, and secondly, they would risk offending the purpose of a language. My client's conduct is the same. I urge a reversal of the court below. Thank you.
Thank you. Mr. Grenzel?
Mr. Chief Justice, and may it please the court, this is a case about a persecutor seeking asylum and a statute that bars asylum to persecutors. We urge this court to affirm the ruling of the Fifth Circuit for the following two reasons. First, the INA is and should be a bright-line rule, at least this provision, and implying a defense of duress would do violence to the meaning of the statute, as understood through congressional intent. Secondly, the CAT, the Convention Against Torture, complements the INA by vesting courts with equitable discretion to defer removal. Thus, there is no need to imply duress in the INA. First, this court's own precedent, as you noted, Justice.
You don't challenge the deferral here?
No. Indeed, by urging an affirmation of the Fifth Circuit's ruling, we urge this court to affirm the deferral of removal of Mr. Ninian. As you noted, Justice England, in the Federico case, the court did not find an involuntariness exception to a very similar statute. The court did direct a particularized inquiry into the facts that constitute persecution. But, as the footnotes make clear, the facts that constitute persecution are relative only to the activeness of the defendant's persecutory participation and the effect the defendant's acts have on victims of persecution. So here, for example...
So under that test, whether the person tries to escape or not doesn't matter. True?
Under that test, it does not matter whether the person tries to escape or not.
In Federico, why did we spend so much time talking about that again and again, about whether the fact that he didn't try to escape, he was allowed to go into town? I mean, it's mentioned several times through the opinion. Why?
The simple answer to that is that the court wanted to convince itself it was making the right decision. But it did read a bright-line rule into a very similar statute. And by noticing the various factors that Mr. Federico was guilty of, i.e. his not attempting to escape when he had the chance, the court was emphasizing that he was indeed a persecutor. However, if we even adopt an culpability analysis like the Hernandez court did and like petitioner urges today, Mr. Ninian is indeed, on many measures, guiltier than Mr. Federico as far as being a culpable persecutor. But the bright line rule, as I mentioned, still allows for meaningful inquiry into the fact of persecution.
How is he more guilty than Federico?
Well, Mr. Ninian, in equal parts, attempted to prevent the escape of prisoners, as did Mr. Federico. Mr. Ninian stood by passively and watched people literally die before him, whereas that was not alleged in the Federico case. Moreover, Mr. Ninian's assistance to individuals in the prison camp was selective and based upon his own personal predilections. So, for example, he assisted the Protestant couple when there's no evidence that he assisted people who shared values that were perhaps not his own. So, though the court...
Wasn't that because it was the Protestant couple that was being persecuted the most? I mean...
I don't believe there's evidence to suggest that Protestants suffered more persecution than other opponents of the government. The evidence is that Mr. Ninian helped the Protestants primarily because he was himself a Protestant.
Well, aren't there 4 religions that are recognized by the state?
Yes.
All right. But getting back to my colleague's question, he was helping the Protestant because that was one of the religions not sanctioned, correct?
He was helping the Protestants because they were his fellows in the prison environment. There were other people in the prison who were not necessarily there for religious violations. They could be there for violations relating to the opposition of the government, for example, and Mr. Ninian chose not to help those. So though the court in Fedorenko determined there was no involuntariness to say,
But didn't Fedorenko limit its decision to the facts of that particular case? Weren't they really focusing there and trying to say that we are limiting ourselves to these facts? And along the lines of the question I asked Mr. Groves during his argument, shouldn't the court now look at things differently in 2008 compared to the way they were in the statutes as created in 1948 and how they were interpreted in 1981? Shouldn't we grow along and understand how things work a little bit differently now?
I'd like to respond in two parts. First, relating to the latter point, Congress did amend the INA as late as 2007. That Congress did not change this provision indicates that Congress indeed accepts this provision as it is. So the judgment of Congress has not changed. Secondly, however, the court in Fedorenko limited itself only to what constitutes persecution, i.e. the facts that constitute persecution. It did not limit its ruling insofar as it determined that the statute in question was a bright line. That is a ruling with precedential value.
But you, go ahead, I'm sorry.
Well, you're following up, go ahead.
You just said that they amended as recently as, and thank you very much, Mr. Chief Justice. But did they leave in the word voluntary, or that term in the INS?
In the INA, there is no,
INA, excuse me?
There is no voluntariness requirement.
Well, isn't that what our predecessors relied upon extensively in Fedorenko? And looking at Section 2A versus 2B, that if Congress had desired to put the word voluntary in, they would have. And now that it's been taken out, which way do we go? Does it make it seem to you that they don't want to have the voluntary issue be a part of it any longer?
I agree that the court or the Congress does not want the voluntary issue to be part of the general inquiry going into it. However, the court in Fedorenko did have the benefit of having a statute that, or provisions of a statute that both specified and did not specify voluntariness, thus allowing the court to conclude when voluntariness wasn't specified that it was intentionally not specified. However, other canons of construction can lead to the same conclusion here, and indeed every lower court has interpreted Fedorenko to, at least interpreting this statute, has interpreted Fedorenko to say that statutes like the one in question are bright line rules. And the bright line rule, as you mentioned, Justice Hinkle, may be intentional. Congress may have made a determination that crimes of persecution of a protected class are so heinous that the duress of defense is not availing. And indeed, there are two salient points to make here about the defense of duress. First, this is a regulatory statute. It is not a criminal statute. To imply the defense of duress into a regulatory statute would do violence not only to the INA, but also to lower courts and the Bureau of Immigration in general. Secondly, the common law defense of duress, even if it were to be implied into the statute, is not available for heinous occurrences. So, for example, the law does not excuse the killing of one innocent life for the saving of another innocent life.
You think in a murder case, if somebody puts a gun to my head and says, shoot that person or I'm going to shoot you, and change the hypothetical, they did this to 3 other people and shot them all, and then they come to me, and I've watched 3 people just get shot, and they said, now it's your turn, shoot this person or I'm going to shoot you, and I shoot the person, you think I'm guilty of murder?
Well, the crude calculus of the criminal law is that killing one person, killing an innocent life to save an innocent life is not sanctioned. Now,
So
you may be guilty.
There's no duress defense in a murder prosecution?
In that case, there wouldn't be a duress defense. However, the sentence would, of course, be lightened given the circumstances. But as I mentioned, the plain language of the statute militates against implying any conditions into the INA. Not only does the statute in its syntax span the gamut from the most voluntary requirements to the least voluntary requirements, from ordering and inciting to participating and assisting, but we can conclude that Congress's lack of inclusion, as you mentioned, Justice England, of a voluntariness requirement into the INA here indicates that Congress did not intend such a voluntariness requirement. Congress did intend a bright line rule. And as I mentioned...
Tell me what your test is for when one participates or assists in persecution.
If one,
We know from Fedorenko and just common sense that there's some things that are bad enough that they do constitute assisting or participating. Some things, cutting the hair is not sufficient. Do you have a test that tells me what is and what is not participation?
several lower courts have decided that hurting or killing a person on the basis only of their membership in a particular class constitutes persecution. So the CAT complements the INA by providing kind of a softening to the harshness of the bright line INA rule. In other words, this court does not even need to read a defense of duress into the INA. The CAT vests trial courts with equitable discretion to defer removal, and there is no need to imply duress into the INA. As you asked, Justice Hinkle.
But then that person goes back. I mean, the only reason for the deferral of removal is because the person now faces persecution somewhere else. It still means the person can't stay in the United States.
Well,
It's forever barred from staying in the United States. I mean, they get to stay here only until they can be shipped somewhere else.
the individual gets to stay in the United States until conditions are safe in the individual's home country or until a suitable replacement country can be found. Yes, it is not the same as asylum rights, but it should not be either. Congress's intent is clearly otherwise. Congress would not have enacted this dual system of INA and CAT that are meant to operate complementary to each other and in tandem if it did not intend the persecutor exception of the INA to operate mandatorily. That Congress inserted the CAT or allowed the CAT to give equitable discretion to trial court judges indicates that the INA was meant to operate as a bright line rule to be softened in certain cases at the trial judge's discretion by application of the CAT.
How do you have a bright line rule when the statute refers to or otherwise participated? Isn't that anything but a bright line rule?
It
Or
would-
otherwise participated?
Otherwise participated goes to the fact of persecution. The court here granted certiorari on the question of, given persecution as a result of compulsion, does it affect the operation of this rule? Now, given persecution, this statute is a bright line rule. But even if we were to disregard all the arguments I've made today, if we were to disregard the precedent in Fedorenko, if we were to disregard the plain language of the statute and the fact that the CAT operates in such a way that implying the defense of duress is not necessary here, the tests of the lower court, in particular that of Hernandez, would not excuse Mr. Ninian's culpability. Thus, this case is not the case in which to imply the defense of duress, even if this court were to choose to do so.
But we would at least have to remand it to the IJ to look at that fact, wouldn't we? I mean, if we decided there is a duress defense, we can't decide as a matter of law that Ninian doesn't qualify, can we?
No, but the facts here militate against even that consideration because his culpability, at least as regards the Hernandez rationale, is so overwhelming as to make the defense of duress here inapplicable. For example, in Hernandez, the individual escaped at the first chance he had, not after 4 long years of service. The individual spent only 20 days in captivity. You contrast that with Mr. Ninian's long time period spent as a guard, not only prisoner, but a guard of fellow prisoners, and include
A
the
guard
fact
who tried to give water and aid that caused him to also receive beatings, isn't that correct?
on several occasions, yes, but in the span of 4 years, those several
They broke his
instances-
ribs and he didn't receive medical attention. So that maybe he was there for a longer period of time, but didn't he undergo actual physical duress or coercion at that point in time?
Certainly he did, and
And shouldn't that be a factor that a court should look at when making a determination as to whether or not duress is actually present?
it should be a factor a court looks at in deferral of removal discretion under the CAT. We are not saying that Mr. Ninian is necessarily a bad guy or indeed as culpable as many of
So unless
many
you're going to
other
get tortured
persecutors.
when you get sent back, you're going to be sent back.
Well-
Under your bright line and rule analysis, if you have been involved in any way, you are going to be sent back unless you can prove you're going to be tortured.
This is the intent of Congress, yes. And the CAT, by vesting courts with equitable discretion here, does not immediately send the individual back. Indeed, it defers removal until conditions in that country are appropriately quiescent, or until a suitable country can be found where the individual is guaranteed not to be tortured. Either way, the individual achieves a better position than he or she was in. Congress envisions citizenship as a precious right, and the rights of asylum as precious themselves. They are not inherent to any individual landing on the shores of the United States. It is within Congress's absolute authority to define the conditions on which asylum may be granted. Here, Congress evinces a reasonably deliberated position that participation in crimes of persecution or in persecutory action in general, when the victims are victims only because of their membership in a certain protected class, is a heinous act, and an act that Congress would like to bar citizens of this United States from the taint of having participated in.
Let me ask you a question about what the law should be. Take Hernandez, a person in Hernandez's position who escapes after 20 days. He gets conscripted at a young age, sees some horrible things, escapes 20 days later. Why should we not give that person asylum?
In Hernandez, the court read...
I take it you would say we should not give that person asylum because there's no duress defense, so he goes back. And you say that's the right result.
I don't say him going back is the right result. I would say deferral of removal is the right result as far as equitable discretion vested under the CAT. So by deferral of removal, that Hernandez, the individual, is not sent back to Guatemala. He's allowed to stay in the United States until conditions in Guatemala are safe enough for him to return. So the INA is not as harsh of a rule as it appears on first glance because it operates in tandem with the CAT. And I do not say that...
Let me ask, if I took the scenario that was thrown out a few minutes ago and changed it so that it wasn't one person shooting and killing another, but rather one person looking at the statute ordering another to engage in hard labor or to subject him or herself to very extraordinary conditions of detention, are you saying that duress, and I made those orders, I issued them because I was under duress. I was told that I would die if I did not order that person to engage in some act. Are you saying duress has no place in an analysis under the INA in that circumstance?
Correct. The place for duress analysis is under the CAT. And this reflects the intent of Congress. As I mentioned before, Congress complemented the harshness of the INA, which reflects, though a considered judgment of Congress, a indeed harsh rule with the discretion of the CAT, which negates the necessity of implying a duress defense to the INA.
So someone who acted under duress then would never have the opportunity to remain as a citizen?
If the action under duress was persecution, then yes. I mean, the considered judgment of Congress is that persecution on account of membership in these protected political classes is a heinous crime to which the duress defense should not attach. Because of the heinousness of the crime, Congress has deemed that asylum is not eligible for these individuals. These individuals are not eligible for asylum in the United States. In its discretion, however, the trial court may defer removal of the individual, thus allowing the individual to stay on the shores of the United States, thus negating the harshness of the INA rule while preserving Congress's intent that asylum not be granted to people who have participated or assisted in persecution of others. So, looking at the Hernandez culpability analysis, as I said, even if you were to decide to imply the defense of duress, not only would Hernandez culpability analysis militate against Mr. Ninian's successful raising of that defense, but other problems with the defense of duress arise as well. For example, the problem of burdens, as you mentioned, Justice Hinkle. There are significant problems of proof here that we will have to wrestle with if we are to allow the defense of duress to be implied under the INA. It's not entirely clear whether those burdens should track criminal burdens or they should track civil burdens, or indeed how the burdens will operate within the regulatory framework created by the INA. In addition, the determination of the Federico Court that there is no involuntariness exception bears directly on the question that we are considering today. Voluntariness and duress both go to issues of free choice. That the duress defense, that involuntariness was not read into the statute in Federico, implies that duress should not be read into the statute today.
Wasn't it read into the statute, though, in footnote 34?
No, voluntariness was not read into the statute. Rather, consideration of what acts might be considered persecution was read into the court's discretion.
But isn't there, you sidestepped it by saying the court was trying to convince itself of its rightness, but the recitation that he was allowed to leave the camp and go to the village, suggesting that he had opportunities to escape, and therefore the duress was being implicitly considered by the court, wasn't it?
I believe that in the recitation of the facts of the case, the court wanted to portray Mr. Federico in a neutral, slanting towards unsympathetic light. And I believe duress was implicitly considered, but if we take that route, then we must also consider that duress was implicitly rejected as well. Thank you.
Ms. Groves?
Mr. Chief Justice, and may it please the court. As you suggest, Justice England, bright line rules need not be blind rules. Lady Justice is depicted with a blindfold. It is to guard her impartiality, not to block her view of reality. This court need not disregard all views of reality as it formulates its decision in this case. And a few points on duress, which has everything to do with this court's reality of both what Congress said in the INA and how it should be so construed. First of all, duress does something that, as a matter of policy, should be very important to this court, and that is that it places the blame where it belongs. Duress is long known for placing the blame not on the coerced, but on the coercer. Indeed, Blackstone wrote in 1769 his treatise on the laws of England at Part 30 that the law only punishes abuses of the free will, and hence, to paraphrase Blackstone, it is highly just that the law does not punish those acts which are born of unavoidable force and compulsion.
What's wrong, though, with Mr. Grensel's suggestion that, look, this is all mitigated by the deferral of removal? You have somebody that wants to come to the United States, there's not enough room in the inn. We routinely turn away people that want to come to the United States. So in this instance, we're going to take somebody who never participated in persecution rather than somebody who did. And we'll defer removal until they can safely go back to the homeland, but they're not going to become United States citizens. We're going to reserve that slot for somebody who never did these things.
Your Honor,
what's wrong with that?
Chief Justice Hinkle, if Congress has said as much, Mr. Ninian would be forced to concur. The issue is they haven't, just like in the Safe Streets Act. They've said nothing to disregard the defense of duress, which is so longstanding and so deeply embedded in our system of justice, and not just the criminal law, that they haven't displaced that. And secondly, it doesn't appear that they can't do both. In other words, if those people, Your Honor, I see my time has left. May I briefly conclude?
Surely.
It doesn't appear that they can't do both of those things, Chief Justice Hinkle. In other words, if someone acted under coercion such that he could have done nothing differently, it makes no sense why he would be excluded from the defense of duress under this statute. For the reasons foregoing, I urge this court to reverse the Fifth Circuit. Thank you.
All right, thank you. The court will be in recess.
All rise.
We can pause briefly if you'd like to leave the room to get a beverage or use the restrooms while the judges are deliberating, but we encourage you to stay close, and once their judges return, you won't be allowed to leave again until their final words are concluded. Thank you. talk to the bailiff and see if he can give us a chance. The judges seem like they're wrapping up. fully extended, it was still only like up to Everyone, please take your seats. The judges are returning. Again, I'd ask that everyone please silence their cell phones and remain in the room until the judges' comments are complete and the reception begins. Thank you.
All rise. Supreme Court is now in session to deliver judgment and comments in the case of Ninian v. Casey.
Please be seated. We talked about whether we should announce the result and then make a couple of comments, or make a couple of comments and then announce the result. And we thought, well, there are two guys in here with a pretty high pulse right now, kind of like when you're a lawyer waiting on a verdict. But everybody else is probably pretty relaxed and having a good old time. And if we just announce the result, you'll quit listening. So we thought we'd make comments first. Neither of you guys has heart problems, right? You're okay? Judge Flanagan?
Well, we'd like to call it a tie, but we couldn't figure out how to do that. We sat back there, and I'll share. When I have a jury trial and it's over, I tell the jury, now, you can say, after they've made their decision, you can say anything you want to anybody or nothing at all. But if you speak, remember that the words of your colleagues came to you in the confines of that jury room, and honor that solemnity of the circumstance and the importance of the occasion. In other words, don't say anything that you're not willing for your fellow jurors to hear. So I'm going to disclose, because I don't think my colleagues would mind, something that we said back there, which is that we would each be so very pleased to have either one of you before us, and maybe one day both of you at the same time again. So thank you very much for giving me the opportunity to become so invigorated by you both. Thank you.
Judge England?
I have to tell you that this is, I've done this quite a few times. This is one of the most enjoyable moot court experiences that I've ever been around. The command of your facts and the law, and the way that you both were able to present it forcefully, but yet with great courtesy, very professional, and with everything else that you have to do was simply amazing. I kept thinking that we're going to get one of you to get off track here in a minute and get nervous and forget where you were going or something, but not once. And I think, as my colleague has just mentioned, that having seen these types of arguments both in the district court and for me in the Superior Court in the state, and also I've sat by designation in the Ninth Circuit, you are both outstanding, and you have no place to go but up. It's just amazing, and I'm very proud to be a part of this entire experience here. You're both to be very much commended, and I can't say enough about the presentation on both sides. Thank you for the opportunity to be here.
And I would just echo what the others have said. I think you're both outstanding. I've judged some moot courts, and usually at the high upper level, 2 L's or 3 L's, and you guys are as good as anybody I've had. You're both really outstanding. I hope I'm not giving away anything here. I was going to mention, and if I'm giving it away, I'm sorry. This is a case on which cert has been granted. I don't know that anybody knew that. But I think anybody in the room, if you get a chance, you ought to figure out when the argument is, and you ought to go see it. It's not that far to Washington. You can get in and watch, and it would be a good experience, and you ought to do that while you're in law school. You won't have many chances when you get out. Before I announce the winner, let me say that I really sympathize as much with the one who didn't win as with the one who did. I had an opportunity to go back to law school a couple of years ago to judge a moot court, and with 2 other members of my moot court team. And we were introduced as members of the semifinal team for 1976 or sometime before most of you guys were born. Then when we came back to announce it, the Second Circuit judge, who had been one of my partners now on the Second Circuit, was announcing it, and she said, those of you who are particularly quick on the uptake may have noticed that we were introduced as a semifinal team. What that means is we lost. And so she said, while we congratulate the winner, our hearts are with the one who did not win. And so I very much feel that way. We thought it very close. We have decided that the winner is Mr. Grinsell, so congratulations. Mr. Groves, my heart is with you. And I think then we just recess to, there's food and drink somewhere nearby.
Thank you.